Alhamdulillah, bail has been granted for me. Thank you, police, for taking care of all my belongings. I need to check all of them. By the way, it's getting late. Oh, my defense counsel, Mr. Haris. Hello, Mr. Haris. How are you? I'm fine. Just get out of the jail. What? Pre-trial conference? In 3 days. Okay, sure. In your firm, right? Alright, I will be there in 3 days. Thank you, Mr. Haris.
Oh, hi, Assalamualaikum Arif. Good morning.
Hi, Waalaikumsalam Filza. How are you?
I'm fine, Alhamdulillah.
Filza, aku dengar kau dah kahwin tapi aku tak dapat pun kad jemputan kau.
Bukanlah. Sebab it's only for close relative and the invitation is only for 50 people. So nanti aku belanja kau lah.
Betul aku tunggu tau.
Okay, the best food in KL.
Okay. Assalamualaikum, Council Harith. How are you lately?
Alhamdulillah. Please be seated.
Yeah,
Good morning, Miss Iza. How was the traffic today?
It was good, Alhamdulillah.
So, how's your Ramadan so far, guys? And where do you guys do your tarawih?
Alhamdulillah, my Ramadan is going well. I did my Tarawih at Masjid Bangsa yesterday.
Oh, I just did tarawih with my husband at home je lah. By the way, I saw there was a bazaar Ramadan in front of your building. So how was the food? Is there anything that you would like to recommend?
Yes, the bazaar. You know, from what I heard from my colleague and also my interns, the foods there, you know, man, some said that they are selling, you know, a lot of viral stuff like ayam bakar, you know, those coffee stuff, cheesy stuff, and I do think that you should check it out.
Oh, that sounds nice. Maybe we should go one day?
Yes, of
I
course.
guess this is the meeting room. Assalamualaikum everyone. I'm sorry I'm late.
Waalaikumsalam. It's okay, Cik Vicky. Take a seat. Alright, as all the members are here, so I think we can begin our session.
Assalamualaikum warahmatullahi wabarakatuh and good morning everybody. I am Tengku Arif, the assigned Deputy Public Prosecutor for this case, Public Prosecutor against Fikri bin Muhammad. Together with me today is my Senior Deputy Public Prosecutor, Filza Huda, who will assist me in today's session.
Assalamualaikum and good morning everyone. I am Filza. Nice to meet you all.
Waalaikumsalam. I am Muhammad Harith, the first defense counsel, and together with me is my junior defense counsel, Nurul Hanan, and we are going to represent our client for today, which is the accused, Encik Fikri bin Muhammad.
Hi everyone. So Mr. Haris introduced me. I'm Nurahana binti Azman, the second counsel representing our client in this case.
On that note, welcome to the pre-trial conference for the case of Public Prosecutor against Fikri bin Muhammad. I would like to clarify with the counsel, is the one sits beside us is the accused?
Yes. Encik Fikri, do you mind introduce yourself to the prosecution?
Yes, sure, Mr. Haris. My name is Fikri bin Muhammad and I'm the accused in this case. It's nice to meet you guys.
Nice to meet you. So as we had agreed, today, 22nd of April 2019, is the date of our pre-trial conference, right?
Yes, it's correct, Puan Deputy.
Well, we'll make note of that. Also, at the same time, since everyone is here and everyone present, why not we start this session properly? Therefore, today we will conduct a PTC pre-trial conference in accordance with Section 172A of the Criminal Procedure Code. This section was enacted to speed up this session or the disposal of cases.
In addition, Pursuant to Section 172A, Subsection 2 of the CPC, within 30 days from the date of the accused, Encik Fikri was charged in court or any reasonable time before the commencement of the case management, a pre-trial conference shall commence. Furthermore, Section 172A, Subsection 4 of the same code streamlines relevant matters which the prosecution and the defence may discuss to speed up the trials. In this pre-trial conference, we will discuss several matters which include, firstly, to identify the factual and legal issues, secondly, to narrowing the issues of contention, thirdly, to clarify the position of each party, fourthly, to ensure that we comply with Section 151A, which is the delivery of documents. Next, to discuss the nature of the case for both the prosecution and the defense, including any alibi defense, and lastly, any other matter which expedites the disposal of the case.
That everyone is clear as my co-counsel has briefly everything. Before I move forward, would any of you put forward any question or concern or any doubts that render any clarification?
No, Tuan DPP.
Okay, I'll make note of that. For the purpose of documenting the outcome of this pre-trial conference, also known as PTC, we will prepare the pre-trial agreement known as the PTA at the end of this conference that shall be signed by all the parties, including us, the co-counsel, and also the accused. Upon signing, the parties are regarded as having waived the rights or any matter to be resolved in this PTC without bringing to the trial. Counsel, did you brief your client regarding this matter?
Yes. My client fully understand regarding this pre-trial conference and also the consequences of this PTC.
Tuan DPP, I fully understand about the process of pre-trial conference.
Alright, Alhamdulillah. If all the parties are clear about our agenda today and there is no further question, we should proceed with our PTC.
There is no further question for DPP, and I think we can proceed.
Before we discuss further, let me begin with this pre-trial conference PTC by reading the charge sheet first. That you, Fikri bin Mamat, with the identification number 711010057107 on 15th February 2022 at about 11:30 p.m. in a room at a terrace house at number 8 Jalan 17/9K Taman Minda with the zip code 56,000 Cheras, Wilayah Persekutuan Kuala Lumpur, committed rape on one Marisa binti Abu with the identification number 050510016712, and you thereby committed an offence punishable under Section 376, Section 3 of the Penal Code.
Encik Fikri, do you understand the state charge against you?
Yes, I understand, but Puan, I did not commit rape.
It's okay, Mr. Fikri. Calm down. The prosecution was just reading to you the charge. It's okay, we got you.
Okay, I'm sorry.
Okay. As we had read the charge, then we will proceed with the fact of the case based on investigation paper filed against us. So, if the defense counsel has anything agree or disagree, you can say it to us.
Yes, we will inform you if we have either agree or disagree facts during this discussion.
We will make note of that. Therefore, I would like to proceed with this session. The facts of the case are that the accused, Fikri bin Mamat, is a public servant working as an officer at the Selangor Land Office, Shah Alam. On the 20th January 2022, the accused married a nurse who is a single mother and has a 16-year-old daughter named Marisa binti Abu from her previous marriage. After the marriage, you reside with the victim and your wife at Jalan 19/5K, Taman Midah, Ceras, Wilayah Persekutuan Kuala Lumpur. Is this fact correct, Mr. Fikri?
Yes, it is correct, Tuan DPP.
So on 15th February 2020, at about 8:30 p.m., you held a majlis kesyukuran for your promotion at your house at Taman Mida and had invited several close friends to celebrate the occasion. So do you agree with this fact?
Yes, I do.
However, at about 11:30 p.m., you entered your stepdaughter's room, who was sound asleep, and you pressed your body on top of her and addressed her. Subsequently, you pulled down your trousers. Then, the victim woke up when she heard the sound of a belt unzip being opened. While being on top of her, you had then inserted your penis into the victim's vagina. During this incident, the victim's face was covered with a pillow. Do you agree with these facts, Mr. Fikri?
It is not rape. I swear to it. She consented to it.
Calm down, Mr. Fikri. It's okay. By the way, Puan DPP, may I know how the victim described the penetration?
So at that time, the victim stated that she felt the accused penis enter her vagina. This is because she had felt pain, felt a hard object during the act, and she tried to resist but to no avail. However, as the room was dark, she could not see his private part clearly, but she concluded that based on the body smell of the accused, he is the one who raped her.
No, I did not put my penis into her. This is absolutely wrong. Encik Aris, could you tell them that I didn't do it?
Calm down, Mr. Fikri. I will discuss this the purpose for the PTC. Puan DPP, for the facts that you just mentioned, we want to put that fact in the disputed fact that we will contest in the trial letter.
Okay. We will take note of that. So, are there any facts that the council wish to add?
Basically, we would like to emphasize that there was actually no penetration done by our client. As from the surrounding, it was very dark and the victim couldn't see who was the real culprit. Therefore, the victim had relied solely on the smell of the body. Furthermore, the victim also wasn't sure whether it was the private part of the accused that had entered into the vagina. So that is the fact that we would like to emphasize.
I see. Well, I put that in our record. Are there any other facts that the defense counsel would like to add on behalf of the accused?
Yes, we want to add some other facts. The second fact that we want to add, my client would like to emphasize that there is no offence of rape committed by him, as the sexual intercourse was consent by the victim and also the accused at that night, and the accused felt that there is no resistance to his advance by the victim during the commission of the act. That's all that we would like to add. You have taken note all of the facts?
Yes, don't worry. So other than that, your client had agreed with all the facts read by us just now, right?
Yes, all of the facts are already agreed by my client.
Based on the facts, we have managed to deduce a few legal issues. First of all, the main legal issue to be discussed is whether the accused is guilty for the offence of rape under section 376, subsection 3 of the Penal Code. Next, the issue that follows is whether the accused had fulfilled the elements of actus reus and mens rea under section 375 of the Penal Code for raping the victim.
So then, referring to the main legal issue just now, we would like to propose the following legal issues, which are: first, whether there was indeed penal penetration of the accused's private parts into the victim's private parts, and secondly, whether the accused honestly believed that the victim consented.
For your information, Mr. Fikri, these issues will be discussed during at the trial.
I see. Okay, then I'll be trusting of you guys.
Okay, we understood and agreed on the legal issues. Basically, on the first one is whether there was a penetration to constitute rape under section 3763 of the Penal Code, and secondly on whether the accused believed that the victim consented to the act.
As both of us had thoroughly explained everything, I hope we are on the same page concerning the factual and legal issues. Now we will proceed with our second agenda, which is to narrow down the issues of contention.
Yes, 20PP, we are already clear with the factual and also the legal issues. Sure, prosecution can proceed.
Alright, since all of us are clear, now we will proceed with detailing the issues of mens rea and actus rea to be used in the trial that will be held at a future date.
Before that, may I take some time because I would like to explain clearly to my client the exact meaning of actus reus and mens rea in order for him to further understand what are we going to discuss about after this.
Yes, you may.
Thank you, Tuan Deputy. Okay, now Encik Fikri, for your ease and clear understanding, I will explain to you the meaning of actus reus and mens rea. Therefore, I hope that you can give me your full attention.
Sure.
And if you have any question, please don't hesitate to ask me because this is a very serious term that you need to understand. Okay, regards to actus reus and mens rea, basically these two are the twin pillars in crime. And the first one is actus reus. As you can hear from the name act, it is basically mean guilty act, and it is the action or conduct that constitutes the elements of the crime. This means that it is about the physical action that the accused have committed. On the other hand, mens rea is about the guilty mind. It is the mental element, i.e. the intention to commit the crime. Basically, anything that you have on your mind when during the time of the commission of the crime, and that is mens rea.
Mr. Fikri, the reason that we need to ensure that you really understand the elements of actus reus and mens rea of rape, the offence of rape, is that if the elements of actus reus and mens rea fulfill the requirement, you will be guilty for the offence of rape. So, do you really understand the concept actus reus and mens rea?
Yes, I understand it well. Thank you for your explanation.
Okay, since the accused had expressed his understanding on what is actus reus and mens rea, so the importance of the two elements that you may now proceed, 20 pp.
For sure, I will act accordingly. Pursuant to the charge that I had read earlier, the accused is charged under section 376, subsection 3 of the Penal Code for committing incestuous rape to the victim who is his own stepdaughter. Therefore, to make a prima facie case against the accused for committing the offence of rape, the elements of rape under section 375 of the Penal Code, including the actus reus and mens rea of the accused, will have to be proven by us at the prosecution at the prosecution stage in this case.
So with regard of the first element, which is actus reus, it must be proven that there was indeed penile penetration of the accused's private part into the victim's private part. So we have ample evidence that shows that it was the accused's private part that had penetrated into the victim's private part and not any other foreign object. So hence, such act clearly shows that the commission of the offence of rape by the accused himself.
On that note, with regard to the second element, i.e. mens rea, we as the prosecution need to prove that there was an intention by the accused to commit the offense of rape. In proving that the accused has the intention to commit the offense of rape, we have sufficient proof to show that the accused has the mens rea specified under section 375, paragraph A and B of the Penal Code. Therefore, these would be the contentions of the prosecution.
However, as the defense counsel of the accused, we would like to disagree with the contention of the prosecution that has just been made earlier, because we are of the view that our client did not fulfill the two elements of actus reus and mens rea.
So our client would like to argue that there was no penetration done by him since he did not enter his private part into the victim's private part. So he contended that he is an important man and he only inserted his finger into the victim's private part. He also believed that the victim had consented to the act since there is no resistance during the commission of the act. That is our contention for this case 20 pp.
Now we would move forward to our third agenda. We would like to clarify each party's position. The prosecution side believes that this is a clear-cut or prima facie case. The victim had testimonied that she had been raped by the accused during the night when the accused held majlis kesyukuran. The victim mentioned that she was forcefully undressed and being helped, while the accused inserted his penis into the victim's vagina.
That is true. Furthermore, we also obtained the statement from Dr. Nagasiran, who examined the victim. She testified that there was a fresh find on the victim's hymen and there was internal bleeding in her vagina resulted from the sexual intercourse. Hence, we believe that this is indeed a prima facie case of rape.
We beg to differ 20 pp and also 20 pp. We find it absurd that this is a prima facie case as the vital element of actus rea whereby there was no act of penetration by the accused to the victim's private part.
Yes, I agree with my counsel that there is no penetration and I only inserted my finger and she has consented to it and as she did not objected when it happened.
Very well then, we will record that. If that is what you contended, we suggest for the defense to bring all the witnesses and put forward them to prove your contention.
Alright, we will surely prove our contention and call upon witnesses. And on that matter, I think we can proceed with the next agenda.
Since you are clear with our prior agenda, we would now move to the discussion on the documents that are related to this case as provided under section 51A of the Criminal Procedure Code. As the prosecutor needs to deliver the necessary documents to the accused. Here, we bring the documents for your perusal. You may check accordingly.
Thank you, 20 pp. Are these all the documents that the prosecution have?
There are more documents, but the documents presented here are the most relevant to your case.
Alright, 20 pp. I think we can go through each of the document that you just handed just now.
Okay, first, I have given you the charge sheet that contains the charge against the accused.
Okay, Encik Fikri. This is the charge sheet which basically contains the accusation made against you. And now I will read it to you again, the charge against you. That you, Fikri bin Mamat, your IC number 710112140707, on the 15th of February 2022 at about 11:30 p.m. in a room at a terrace house in number 8 Jalan 17/9K Taman Midah 56,000 Ceras, wilayah Persekutuan Kuala Lumpur, committed the offence of rape to your stepdaughter Marisa binti Abu and her IC number 040410140922, and you have thereby committed an offence punishable under section 376 subsection 3 of the Penal Code.
Okay, the next document that I handed is the first information report known as FIR dated 16 February 2022 that was made by the medical doctor who examined the victim on 16 February 2022 at 12:55 a.m.
Just to reconfirm, the report was made by the medical doctor.
Yes, we also handed the medical report from Hospital Pantai Juras together with the chemist report.
By the way, this hospital is a private hospital, right?
Yes, and the report stated that there is a tear at the victim's vagina.
Okay, 20 pp. From the prosecution list witnesses, there are 5 witnesses which are victim herself, her mother, the medical doctor, the chemist, and IO. Is that correct?
Yes, to your question. Now I would like to put a query. May I ask how many witnesses that the defense counsel intend to call?
Well, the defense, we plan to call the accused as the witness, the first witness, and then we also will call the accused friends that attended the Majlis Kesyukuran. They also will become some part of the witnesses. And the last person that we will call would be the medical doctor who has examined the accused health in detail.
Okay, so for the last document, we also given you the statement from the first and second witness, and also the statement of the accused.
Alright, thank you for that. So we agree with all the evidence, and there is no objection from defense regarding the evidence tendered by the prosecution.
Good to hear that. We would now move forward to the next agenda to discuss the nature of the case for the prosecution and defense. It is to be reminded that in order to prosecute the accused under the offence of rape under section 376, subsection 3 of the Penal Code, the burden of proof must be beyond reasonable doubt.
As we have been discussed, the prosecution need to establish that there is penile penetration and intention to commit rape by the accused. So if the accused is found guilty, he may be sentenced to minimum 8 years and not more than 30 years imprisonment, and whipping not less than 10 strokes. Therefore, counsel, do you intend to bring any defense to your client?
Yes, Puan DPP. As earlier, the defense disagreed on the fact that there was no penile penetration, and then in regards to also the intention to commit rape on behalf of our client, thus it is on our intention to bring the defense of, firstly, that our client had actually been diagnosed with the disease of impotency, and second, there was no penile penetration, and thirdly, that our client had mistakenly believed that the victim consented to his act.
If I may clarify, do you have any proof to show and indicate that your client is impotent?
Yes, we have the medical report that shows that our client is impotent.
Okay, I will take note of that later.
Now we have reached the end of our conference. Before we finalize the session, I would like to clarify certain matters relating to this case. As we have unanimously agreed on the crucial issues, the prosecution now will provide you with the entire week. Should you have any other matters or concerns that you wish to discuss later, then we may conduct our second meeting. Otherwise, the prosecution will set up a date to proceed with the case management.
Understood, Tuan DPP. We will have another discussion with our client, and if further discussion with the prosecution is necessary, then we will surely meet up again.
Thus, we to tender the following evidences before the court, which are firstly, the charge sheet which stated the accusation against the accused. Okay. Second, the FIR dated 16th February 2020, which was made by the medical doctor who examined the victim on 16th February 2022 at 12:55 p.m. Okay. Thirdly, the medical report from Pantai Hospital Cheras. Fourthly, the chemist report from Pantai Hospital Cheras. The prosecution list of witnesses. The statement from the first and second witness. And lastly, the statement of the accused. And all the evidence mentioned are considered as agreed evidence. Please review this report, and if you are satisfied with it, you may sign this agreement.
This is the pre-trial agreement that we have prepared. The signatures are needed here, therefore I will be signing first, and you and your defense counsel accordingly.
Alright, Tuan DPP. I
Yes.
will be putting my signature here.
Please.
Okay, I will sign as well.
Alright, Encik Vikri, can you please sign this agreement? Here.
On that note, I believe that is all for today. Thank you all for attending this pre-trial conference.
Okay, we also thank you to the prosecution for attending this conference.
You're most welcome. We are glad to be in the same desk with you.